This is Judge Roy Pearson. 15 years ago, he sued his dry cleaners for $54 million after he accused them of losing one of his expensive pairs of pants.
The case of the $54 million pants. A judge suing a dry cleaner over a pair of allegedly missing trousers has to leave the courtroom in tears over the missing knickers.
Now, you might be thinking this story sounds like a good old-fashioned case of an absurd lawsuit. But the man behind the suit absolutely stole the show with how long and drawn out he let the case get, motivated by his own baffling understanding of the law. In truth, this is a story over a decade and a half in the making, with outcomes still being decided as recently as 2020. So how on earth did this lawsuit even get to trial? What was the final decision? And what exactly was the deal with Judge Roy Pearson? The Chung family immigrated to the United States from South Korea in 1992, opening their first laundry services not long after. Years later, they did well enough to open Custom Cleaners, a dry cleaning service that did everything on site. Even as they became a fixture in their Washington, D.C. neighborhood, Sue and Jin Chung spoke little English. A newly separated lawyer named Roy Pearson moved into the neighborhood in 1999 and started frequenting Custom Cleaners not long after. He got along well with the Chung family for the first few years, but took special care to note their satisfaction guaranteed sign hanging in the shop. Roy began having troubles with the Chung family in July 2002, when he accused them of losing a pair of pants he had brought in for them to work on. Their son Jay was on staff that day, and when he couldn't locate Roy's pants, he offered the market value of $150 to try and honor the promise of satisfaction guaranteed. Roy came back to collect his money a few days later, but Jay asked that they change the amount to $80 since the pants weren't new. Roy remained insistent on the previous agreement and was handed a check for $150. For now, all seemed well. Roy returned a week later to drop off more clothes, but the family matriarch Sue Chung told him that the family no longer wanted his business. Using his legal background to his advantage, Roy argued that this may be unlawful in light of their satisfaction guaranteed sign. In effect, Roy was trying to force the Chungs into continuing to service him through vague legal threats. But Sue didn't budge. Roy wrote a letter cautioning the Chungs that their decision could be considered an unfair trade practice, as it made the promise of satisfaction guaranteed a conditional one. He was later telephoned by a friend of the Chung family who point-blank asked him why he didn't just go to a different dry cleaner. Roy would have none of it. It seems he managed to change the family's mind after telling them he didn't have a car, and that he relied on them because they were the only dry cleaners in his neighborhood. He therefore continued retaining their services for the next 3 years, despite this awkward experience. But before long, Roy again found fault with the Chung family's dry cleaning business. The year was 2005. Roy had just been hired on as an administrative judge, and he wanted to look good on his first day. Unfortunately, his fancy Hickey Freeman suits had gotten a bit tight on him, so on May 3rd, Roy brought the pants from each set in to Custom Cleaners for alterations. He asked that the pants be worked on in consecutive order, as he couldn't afford to have all 5 done at once. Roy told the court that when he came in to claim one of the pairs, Sue told him that she was unable to finish the job. He went on to request that they be returned unaltered, to which Sue clarified that she had in fact gotten the alteration done, but had left them in a cart for pressing. Sue couldn't find said pants, and told Roy they must have been accidentally sent to one of the family's other stores. Roy said he was promised they'd be ready to go by 7:30 the following day. The next morning, Sue still hadn't found the pants, but had finished work on a different pair. Roy said that the suit of the lost pair was worth over $1,000 and that he expected to be compensated. When his credit card was declined, he was unable to afford the bill for the work done on the other pants. Before leaving, Sue asked if he could bring in the suit jacket from the Hickey Freeman outfit to help track down the missing pair. Roy agreed. He went back to Custom Cleaners on the 14th of May and claimed that Sue tried passing off a different pair of pants as his original. She countered that given the pants' altered measurements matched identically to those requested by Roy, these were, in fact, his pants. Despite the shop's records, tags, and Roy's own receipt suggesting these were the lost pants, the man refused to accept them. He demanded $1,150 to replace the pants, which Sue refused. The irritated Roy then complained that the Chungs had been giving him poor service for years, and stormed off to write a letter outlining the provisions of DC's Consumer Protection Procedures Act. Demanding triple damage for how the family treated him, Roy sent individual copies to owners Sue Chung, Jin Chung, and Ki Chung. The Chung family lawyered up and attempted to settle outside of court. They offered Roy $3,000, $4,600, and finally $12,000 to get him off their backs, with each successive amount denied. This would be important later on, as if Roy didn't recover more than these amounts at a trial, he'd be on the hook for their legal costs. Before long, Roy filed a lawsuit in the District of Columbia Superior Court. The suit contended that the Chungs had tried defrauding Roy by giving him the wrong pants, and that both the satisfaction guaranteed and same-day service signs were misleading customers. The Chungs moved to have the case dismissed, but because there were some facts in dispute, presiding judge Judith Bartnoff had no choice but to allow it to go ahead anyway. By March 2007, Roy was seeking $67,292,000 in damages. This figure was based on the idea that he deserved $1,500 for each violation of DC's Consumer Protection Procedures Act, which by his definition was every day for over 1,200 days during which the offending signs were posted at custom cleaners. ABC News calculated that Roy could, quote, buy 84,115 new pairs of pants at the $800 value he placed on the missing trousers in court documents. Just before the trial began, Roy lowered the claim to a little over $54 million. The Washington Post broke down his reasoning for such an outrageous amount as follows. Quote, Pearson said he had no choice but to sue, because he is a private attorney general standing up for every person in Washington. Pearson told the judge he wants $500,000 in attorney fees, though he represents himself, $2 million for his discomfort, inconvenience, and mental distress, and $51.5 million that he would use to help any DC resident sue businesses just as Pearson has. Roy also believed he was entitled to $15,000 to cover the cost of renting a car every weekend to get his dry cleaning done elsewhere. The stress of the ordeal was so great the Chung family contemplated leaving everything behind to return to South Korea.
We thought about going back to Korea, but it was impossible. Even now, it is too difficult to talk about. I felt heartbroken and overwhelmed.
But they weren't without allies. News channels derided the ridiculousness of Roy's lawsuit, as did the people they interviewed in the street.
It's just puzzling, to see a person go to that extent, and then to see the system back it up. It's a lot of nonsense.
Word of mouth about the vexatious lawsuit spread and won the Chung family many supporters. A defense fund was launched online, raising enough money to cover the lion's share of the Chung's legal fees. The Institute for Legal Reform even held a fundraiser featuring both the Chung family and the pants at the center of it all, to resounding success. Even with all the support, however, the weight of the ordeal put a heavy strain on the Chung family. Indeed, the only thing that could alleviate their stress was the imminent court hearing, where they hoped the justice system would see reason and rule in their favor. The two-day trial began on June 12, 2007. As the Washington Post reported, Roy chose to represent himself on the stand. The Chungs, on the other hand, hired their own counsel. Roy maintained he was the underdog in the fight, stating in his opening arguments, quote, "Never before in recorded history have a group of defendants engaged in such misleading and unfair business practices." Very quickly, the trial became less about the pants themselves and more about Roy's impression that the Chung family were a bunch of scammers. Roy even withdrew some of his claims during his trial brief, making sure to note that, quote, "Plaintiff is not suing for lost pants." This created ambiguity about what exactly it was he was suing over, though Roy insisted that the ordeal over his missing pants was still part of the evidence against the Chung family's trade practices. He told the court about the sign at custom cleaners promising same-day service to customers, asserting that they didn't honor this when he saw a customer try and drop off pants after 4 p.m., even though the shop closed at 7. He also brought up the ever-important satisfaction guaranteed sign. It was Roy's belief that this could legally be interpreted as, quote, "an unconditional and unlimited guarantee of satisfaction as a matter of law." He testified that this included situations where business owners knew that the customer was lying, or if customers demanded as much as $1 trillion in compensation. For his part, Roy claimed to be fighting on behalf of consumers everywhere who had been duped by businesses with misleading standards of practice. Yet Judge Bartnoff remained unconvinced of his resolve. During the trial, the Chung family attorney Christopher Manning characterized Roy as, quote, a bitter man, emotionally distressed, who has irrationally and uncompromisingly pursued this litigation. He wanted the Chungs to suffer. Throughout his case, Roy called on a number of unusual witnesses, including his own son, who he hoped could confirm details of what the pants looked like since he had borrowed them off his dad at one point. Roy also brought 4 other clients of custom cleaners who he claimed were dissatisfied with their service, such as an 89-year-old woman who compared the Chungs to Nazis. Unfortunately for Roy, this backfired. Most of his witnesses agreed that they'd be satisfied with at-cost financial compensation for any lost clothing, and contradicted Roy by agreeing they had mostly good experiences doing business with the Chungs. Later in his testimony, Roy had broken down in tears over his lost pants. A recess was called, but the judge refused Roy's request to finish his testimony in writing. Day 2 proved just as interesting. Roy brought up his own divorce trial from years prior, wherein the Virginia Appeals Court accused him of abusing the legal system by badgering his ex-wife with almost 250 demands to responses for questions. He was sanctioned $12,000 in legal fees by the court, who charged him of, quote, creating unnecessary litigation and threatening both his wife, Rhonda Van Lowe, and her lawyer with disbarment. Apparently, the marriage collapsed after Roy tried to banish Rhonda's daughter from their home. Though Roy had requested spousal support from his wife, this was denied. The divorce appears to be why he was in such dire financial straits in wake of his appointment as administrative judge in 2005. Judge Bartnoff questioned Roy on whether he was using the pants lawsuit as a means of relitigating his divorce, shutting down any attempt at him painting the Virginia court as being unreasonable. The rest of the afternoon followed in similar fashion. Roy continued airing his own dirty laundry without much sympathy from Judge Bartnoff. At one point, she finally relented, quote, I don't know what we're doing at this point. As for the defense, the Chungs related that the ordeal had wiped out their entire family savings and ruined their credit rating. Sue Chung began crying on stand, talking at length about how much turmoil the outrageous lawsuit caused them. The family reiterated their belief that the pants they offered back to Roy were his, noting that they also matched the measurements of the other pairs he had left at Custom Cleaners. Though Sue testified that the business had never before or since received a complaint over their Satisfaction Guaranteed sign, they removed it out of an abundance of caution. After hearing from the defense's own character witnesses, the court sided with them as the more credible party, adding that Roy had failed to meet the burden of proof necessary to show that the Chungs had tried cheating him. Judge Bartnoff's decision was clear. Roy had not proven beyond a reasonable doubt that the Chungs lost his pants, and absolved them of the $54 million lawsuit. She also challenged Roy's interpretation of consumer protection laws, writing in her ruling, quote, a reasonable consumer would not interpret satisfaction guaranteed to mean that a merchant is required to satisfy a customer's unreasonable demands. Judge Bartnoff maintained that while she appreciated the need for consumer protection laws, she wouldn't allow them to be grossly manipulated to avenge personal slights. All in all, it was the ever-expanding scope of Roy's case, along with his rubbery interpretation of the law, which shredded any chance of him winning the trial. And this would inevitably stain him professionally. Judge Bartnoff told Roy he was on the hook for the Chung family's court costs, and had yet to decide if he should cover their lawyer fees as well. Roy, of course, protested. The Chung family, on the other hand, was just happy for it to all be over. They sold Custom Cleaners and one of their other dry cleaners in September 2007, wanting to wash their hands of the experience. The Chungs lamented that their business had taken an enormous hit, which, coupled with the emotional stresses, made selling an easy decision. NBC reached out to Roy for his thoughts, but received no comment. Roy was far from finished. He believed the judgment to be unfair, petitioning Judge Bartnoff to reconsider her decision, lest he pursue the matter further with the D.C. Court of Appeals. In his words, quote, the court effectively substituted a guarantee of satisfaction with reasonable limits and preconditions for the unconditional and unambiguous guarantee of satisfaction the defendant merchant chose to advertise for 7 years. That was a fundamental legal error. Unfortunately for Roy, Judge Bartnoff denied his request, stating that all he did was re-argue the same case. This, of course, left him incensed. But there were other, more pressing matters Roy had been neglecting. The man's actions throughout the court case had cast doubt on his competency as an administrative judge. The public, who had derided the ridiculousness of the trial and how it affected the Chung family, began demanding the district government take a closer look at Roy's fitness as a legal professional.
I just wonder if in 2 years or 3 years we're reading about this being at the Supreme Court level. That scares the living daylights out of me.
Roy's 2-year tenure as administrative judge had finished in April 2007, giving them an out should they choose not to renew his appointment. By August, the Commission on Selection and Tenure of Administrative Law Judges concluded that his lack of judicial temperament in the Chung case made him decidedly unfit for a 10-year reappointment to his post. He was thus out of a job come November. Nevertheless, Roy launched an appeal of Judge Bartnoff's decision. Meanwhile, the Chungs continued to receive an outpouring of support and financial backing for their crowdsourced legal fund. Though they had initially sought to recover the tens of thousands of dollars owed to them in legal fees, the Chungs were tired of dealing with Roy and his constant litigation. And since the crowd fund covered their bills anyways, they decided to leave well enough alone. But burying the hatchet, even in the face of certain defeat, was too much of an ask for Roy Pearson, who lashed out at anyone and everyone over the career he himself destroyed. In May 2008, Roy sued the District of Columbia for $1 million, claiming wrongful dismissal for exposing corruption within the Office of Administrative Hearings. He also demanded reinstitution as an administrative judge. Quote, confident that the media storm would provide cover for a retaliatory demotion, the defendants made little effort to mask the retaliatory motive. As with the Pants lawsuit, Roy claimed he suffered both physical illness and humiliation. He also claimed to have been targeted for blowing the whistle on improper workplace procedures, with little to back this up. His appeal of the Pants lawsuit was denied on December 18, 2008, with the DC Court of Appeals writing that Roy's claims were utterly unmerited. Despite yet another resounding defeat, the tenacious former judge was somehow still not finished. Roy filed a petition to the ruling on January 6, 2009, seeking to have his case heard by the entire 9-judge panel of the DC Court of Appeals. He pointed to the fact that the courts allowed his case to get all the way to trial as proof of its validity, though the Court of Appeals retorted that his increasingly unhinged legal theories destroyed his credibility. 2 months later, the court denied Roy's request. His only recourse would be to take it all the way to the United States Supreme Court. Though he decided not to follow through on this, he still had his wrongful dismissal suit in his back pocket. Unfortunately for Roy, in late July 2009, his lawsuit against the District of Columbia was thrown out by U.S. District Judge Ellen Huvel, who referred to his case against the Chung family as a, quote, personal vendetta. Roy, of course, disputed this, citing his First Amendment rights as a defense for his actions. He challenged the impartiality of Judge Huvel, citing a photograph at an annual Washington Bar Association dinner that showed her mingling with a handful of Superior Court judges. Roy contended that Judge Huvel ought to recuse herself from the case because some of these judges were defendants in his lawsuit. Business Insider also wrote that Roy tried filing a longer brief than was allowed by messing with the formatting on his computer's word processor. Roy claimed this was an honest mistake, and also that it was an irrelevant bureaucratic limitation. But his failure to comply was his undoing. The court refused to accept the lengthy brief and dismissed the appeal. This dismissal was upheld by the U.S. Court of Appeals for the District of Columbia in mid-2010, thus concluding the saga of the Great American Pantsuit. The Washington Post reported in 2016 that Roy might face disciplinary action by the D.C. Court of Appeals over allegations of misconduct. A 3-person panel from the D.C. Board on Professional Responsibility concluded that Roy committed, quote, 2 ethics violations of interfering with the administration of justice and presenting arguments not supported by facts or law. They recommended that Roy face 2 years probation from practicing law, though the final say on the most appropriate consequences for his actions wouldn't be decided for a few months thereafter. Roy was, however, warned to desist from filing any more absurd lawsuits. Roy unsurprisingly remained belligerent. He accused the board of a, quote, transparently frivolous effort to interfere with the administration of justice, and derided the decision as, quote, 144 paragraphs of inflammatory, prejudicial, and legally unfounded alleged facts. The bar admitted they should have done something about Roy sooner, but didn't reveal why it took so long to deal with him. The final decision from the D.C. Court of Appeals didn't arrive until 2020. Roy ultimately received a 90-day suspension because his, quote, litigation tactics went beyond aggressiveness and crossed the boundary into abusiveness. The disciplinary action was in part due to Roy's refusal to accept responsibility over his ethics violations, or to even acknowledge them as such. Roy refused all requests for comment. Despite all that happened, Roy remains a member of the DC Bar. He made headlines again in 2022 when he lost an 8-year-long court battle against his landlord over raised rent. Though Roy managed to get his rent reduced, his demand for 3 years free rent plus triple damages was denied. Roy has since kept a low profile. The Pearson vs. Chung lawsuit continues to be studied by legal scholars as the shining example of frivolous litigation in the American court system. Truly, this case became the white whale to Roy's Captain Ahab, as despite multiple chances to back down and save face, the former judge simply couldn't let go. This anomaly now serves as the perfect example of the phrase, just because you can, doesn't mean you should.